Welcome back to ALECTV here on the third day of the States and Nation Policy Summit in Scottsdale, Arizona. I'm Tom McLaughlin, and I'm joined today by the Attorney General of Alaska, Kevin Clarkson. How are you doing today?
I'm doing very good.
Glad to have you here. So you are, one of the big things that you're working on in Alaska is Janus Compliance. Is that correct?
That's true, yes. When I came into office, Governor Dunleavy asked me to have the Alaska Department of Law take a look at the Janus decision and determine, what does it require, what was the holding of the court, and is Alaska complying with what the court required?
Absolutely. So can you tell me how that exactly works, that whole process?
Well, the Janus decision specifically held that non-union members, public employees who are not members of the union, cannot be required to pay money to the union. What they used to be required to pay was something they called an agency fee. Right. And the agency fee ostensibly was an amount of money that was designed to compensate the union for the collective bargaining activity that it engaged in for the union members, or the people represented by the union, which included non-members. It was supposed to avoid what they call free riders, people getting represented by the union but not paying for the benefit of the service. But the U.S. Supreme Court said that no, that's unconstitutional. You cannot force an individual who's a public employee to subsidize the activity, political activity, and political speech of a public employee union. And even collective bargaining activity that a public employee union engages in is political activity. I mean, if you knew anything about Alaska, you'd know that one of the hottest political issues in Alaska right now is budgeting. Okay. And so that's the very specific holding of Janus. But the governor asked us to take a look at what the broader implications of the decision were as well. And the broader implications are that anytime the government is taking money from one of its employees and giving it to a union, which will then use it to engage in political activity or political speech, that government employer has to have clear and compelling evidence that that employee has made a knowing and voluntary decision to affirmatively opt into the union. And so we determined that's what the court requires. And we then took a look at what Alaska was doing, and we decided Alaska was not complying.
So you guys are, Alaska and your office in general, are really kind of leading the way. You're one of the first states to really undertake this sort of initiative.
Well, I think we may have been the first to have acted on it. We're certainly not the first to have looked at it. And there are other states that are stepping up and looking at it as well as we speak. But what we determined in terms of what Alaska was doing was that Alaska had created sort of what they call, for lack of a better phrase, they allowed the unions to create Hotel California provisions in the contracts, which, if you think about the famous song, you can check out anytime you like, but you can never leave. And so essentially the unions had created little short 10-day windows once a year when employees could opt out of the union. And so if you didn't opt out affirmatively, you were presumed to be in. And we determined that Janus basically holds that, no, you can't presume an employee's in the union. You have to have an affirmative opt-in from the employee before you can force them to subsidize the union's activity. And so we think Janus applies to any money you take from an employee and give it to a union, whether it's a dues or whether it's an agency fee. It's money that belongs to the employee. And so the state has to collect that clear and compelling evidence. The state itself has to collect that evidence. You can't simply rely on the union and say, we'll trust you, tell us who it is that's opted in. No, the state itself has to make sure that those employees have made that affirmative choice knowingly and voluntarily. And then lastly, we determined that we think the Janus decision, because what's required is clear and compelling evidence, that the employees made that affirmative choice, that has to be done contemporaneously. There is no constitutional right that people have that you waive it once, it's waived forever. Waivers of constitutional rights can become stale over time as circumstances change. So, for example, employees might say, yes, I want to affiliate with the union now when they understand what the union's doing now. But a year from now or 2 years from now, the union's activity could change. Their collective bargaining positions could change. The speech they engage in could change. The candidates that they support will change. And so employees have the right to make their decisions based upon contemporaneous information at the time. So we determined that we think the Janus requires that the affirmative opt-in by the employees has to be contemporaneous. And so that means, in a nutshell, the employees have to have a periodic option periodic time frame within which they can exercise that right to opt in.
Absolutely. I imagine you've met with some pushback on this.
Oh, the unions didn't take it well. Within 2 days, we were in litigation, and we're in litigation now. So stay tuned in terms of how that's going to turn out. We'll let the courts decide how this will all pan out. We think we're right in terms of how we interpreted Janus. And the goal isn't to try to trap employees out of the union. That's not
Right.
the point. The point, I mean, if someone wants to join a union, more power to them. That's their right of association. But the employees who choose not to, it's important to make sure their rights are protected. And so if the employee chooses not to affirmatively opt in, and first of all, we want to make sure that they've got all the information they need to make an informed decision about whether they want to or not. And then if they choose not to, we want to make sure that their rights are being respected. And so the governor issued an administrative order following our advice. And under that administrative order, just to show you how this was not designed to try to be anti-union or force employees out of the union, he actually allowed for employees to opt in anytime they want to.
Right.
The point is not to keep people out of the union, it's to make sure that employees have made a knowing and voluntary choice to opt in. And at least once a year, they're put in a position where they have to make that choice.
Absolutely. So in that case, if you're going to bring a message now to legislators or AGs or fellow decision makers that may consider pursuing these policies in the future, what kind of advice would you give them?
Well, I'd just say it's really important for them to take a hard look at the Janus decision. Think about protecting their employees, their public employees' First Amendment rights to association and speech, because that's really what this is all about. Public employees have the right to choose who they're going to affiliate with, who they're going to associate with, and that includes the union that represents them. They can't be compelled to subsidize political activity or speech by that union unless they want to. And so I would encourage them to really look hard at protecting their employees' First Amendment rights.
All right. Well, AG Clarkson, thank you so much for your time today. I really appreciate you speaking to me on the topic. We're going to have plenty more from the third day of ALECTV. Keep it right here for more of these updates. Have a good one.
Thanks. Thank you.